Good day, ladies and gentlemen, and welcome back to another What If video. My name is Vierpie, and as always, it is fantastic to have you. Today's topic is, what if an employee reports for duty whilst being under the influence of alcohol? As employers, you would know that it's not uncommon for employees to report for duty whilst being under the influence of alcohol. However, we need to distinguish between three situations or scenarios. Scenario one is where employees report for duty whilst being under the influence of alcohol. In other words, they are intoxicated. Scenario two is where an employee consumes alcohol on duty, so they are drinking on duty. And scenario three is where an employee reports for duty and has a blood alcohol level which is in excess of the legal driving limit. So those are the three scenarios that we will be referring to. Whether or not alcohol-related transgressions justify dismissal would not only depend on the nature of the transgression, but also depend on the circumstances of each case. Now, if we consider circumstances, we would include the type of business conducted by the employer, the position or function of the employee, as well as the provisions of the employer's disciplinary code or policy. For example, consumption of alcohol while at work and whilst the employee is on duty is normally regarded as a serious offence, which may even result in dismissal. Yet there may be mitigating factors, for example, alcohol dependency, that would necessitate corrective action rather than dismissal. On the other hand, an employee who is caught reporting for duty whilst under the influence of alcohol would probably not ordinarily deserve a dismissal for a first transgression. Nevertheless, if the person also behaves in a manner that causes harm to others, dismissal may well be warranted. Again, from a circumstantial point of view, the circumstances that we consider is the employee's position, what the employee does. If this employee is appointed in what we call a safety critical position, generally speaking, we would impose a more harsh sanction when that employee reports for duty under the influence or drinks on duty because of this safety consideration. Employers must also distinguish between employees who are under the influence of alcohol and those who simply have a blood alcohol level above a certain limit, which is usually the legal limit for driving different types of vehicles. Now, the fact that someone's blood alcohol levels exceeds the legal limit does not in itself mean that that person is necessarily under the influence. A company driver, for example, who is caught driving a company vehicle or machinery while over the legal limit certainly should be disciplined and may in appropriate circumstances also be dismissed. However, the allegation against the person should be that he or she or they allegedly drove a vehicle or operated a machine with a too high blood alcohol level, and not that he or she or they was under the influence of alcohol. The latter, the allegation that he or she or they were under the influence of alcohol, can only stick where there is evidence of alcohol in the employee's system. So, for example, through an observation or a test. We would also need evidence that the person's behavior or performance was affected as a result of this being under the influence of alcohol. In terms of the smelling of alcohol, merely smelling of alcohol while not actually being under the influence thereof is not, as a general rule, regarded as a disciplinary offense unless, once again, the employer's disciplinary code or policy stipulates otherwise. Or the person is, for example, required to interact with other people on a daily or regular basis, customers, students, colleagues, etc. If this is the case, then you would have to, as the employer, clearly stipulate that the smelling of alcohol is not permitted and spell out a possible sanction in your disciplinary code. Now, an important question is how employers can establish whether an employee is under the influence of alcohol or whether there is alcohol in the employee's blood, although he or she or they is not necessarily intoxicated. Now, there's three ways in which to do this. Number one, subject an employee to a breathalyzer test, very common procedure. Number two, subject an employee to a blood test. Or three, conduct a visual observation of the employee in the presence of a witness. We have this standard templates, the observation test, smelling of alcohol, bloodshot eyed, slurred speech, strange behavior, etc. Now, while an observation does not require the employee's consent, any of these tests that I referred to definitely does require consent. If you've provided, or if provided for in your disciplinary code, a refusal to undergo a test when there is a reasonable suspicion that the employee may have consumed alcohol may in itself constitute a disciplinary transgression. However, even in the absence of such a provision, an employee's refusal to undergo a test when there are clear signs of possible presence of alcohol may be used as evidence against the employee, although it would not give rise to a separate disciplinary transgression. Obviously, any test offered or conducted must be done by someone with appropriate training and using the correct technology. More about that in a minute. Employers should therefore ensure that their disciplinary codes make specific provision for all the scenarios that we've discussed in this video. Employers should furthermore ensure that your contracts of employment with employees have a clause stipulating that employees are under an obligation to submit to testing if reasonably required to do so, and that a failure to do so will constitute a disciplinary transgression. And then finally, these tests must be conducted by a person who are or persons who are appropriately qualified and using equipment that is up to date and calibrated where relevant. So in disciplinary hearings, an employee may dispute the test result of that breathalyzer test on the basis that the machine or the device is not calibrated. So we want that calibration certificate. We also, in some cases where relevant, would need a competency certificate for the security guard who conducted the test, or the manager or the supervisor. Ladies and gentlemen, that then brings us to the end of this video. As always, thank you for watching, and I hope to see you next time. Bye-bye.